Hi, I'm Heidi Sherman of Brittle Family Law Group. Joe, why don't you introduce yourself?
And I'm Joe Gross with JGP Wealth Management.
So, Joe, sometimes people, when they're negotiating a divorce and spousal support is an issue, the parties might want to do what we call a buyout of spousal support rather than pay monthly payments for a period of time. Can you talk about what the tax implications might be, whether there are advantages or disadvantages to doing a lump sum buyout versus the regular payments? And also, how would you calculate that buyout, what amount that buyout should be?
So I would suggest we do those. Okay.
You want me to stop?
I was going to say we do those separately.
Hi, I'm Heidi Sherman from Brittle Family Law Group. Joe, why don't you introduce yourself?
And I'm Joe Gross with JGP Wealth Management.
Joe, sometimes in a divorce, there's a spousal support issue, and parties might decide rather than making regular monthly payments for a period of time that they want to do a buyout, pay a larger lump sum at one time rather than do regular monthly payments. Can you talk about what the advantages or disadvantages of doing that kind of a plan for spousal support would be?
First of all, in terms of tax implications, there's not a lot because the lump sum is not tax deductible to the payer and not taxable to the payee. It could provide some tax problems to the payer depending on how he or she came up with the funds. But there's a number of mutual advantages, and then there's advantages and disadvantages depending on what side of the coin you're on. Mutually, the parties don't have to deal with each other any longer, and that can be a big deal. And there's no money exchanges any longer. So
Okay, wait, I'm going to stop. Hi, I'm Heidi Sherman from Brittle Family Law Group. Joe, will you introduce yourself, please?
I'm Joe Gross with JGP Wealth Management.
So, Joe, sometimes when parties are getting a divorce and spousal support is an issue, the parties might think it's a good idea, rather than paying monthly support for a long period of time or some period of time, that they prefer to do a lump sum buyout, pay one larger amount of money rather than regular monthly payments. Can you talk about whether or not there are advantages or disadvantages to that kind of a plan?
Sure. There's mutual advantages in that the parties don't really have to deal with each other any longer. The money exchange is a certainty now, with no more possibility of future events changing the outcome. And the other thing is that they don't have to pay, any more professional fees to people like you and me. In terms of the supporting spouse's advantages, it may help assist a asset-rich, cash flow poor payor. There's no need to fund a life insurance policy any longer to secure the alimony obligation.
Mm-hmm.
There's no need for the monthly payments any longer. And like we said earlier, there's no future modifications. In terms of the supporting spouse's disadvantages, there's no do-overs any longer. So if the your ex remarries or cohabitates or even dies, you can't go back and say, hey, I paid you all this money up front. It does limit the liquidity for the paying spouse in that they're going to have to get the money from somewhere. In terms of the supported spouse's advantages, they don't have to worry if that check's coming in or if the check's going to be late any longer. They now have immediate access to maybe a significant sum of money, where they might be able to use it for a down payment on a house, or they could borrow against it or something like that. And again, for them, there's no do-overs, so they don't have to worry about their ex losing their job and not being able to pay their alimony in the future. For the supported spouse's disadvantages, it may provide for a difficulty in budgeting with more assets up front and less cash flow. Some people are not great at budgeting, and if they get everything up at this point in time, they might spend it all up front and not have it at the back end.
Mhm.
And usually the supported spouse will have to give up something for the benefit of having that money up front, in terms of it'll be less money over time. So these are all things to consider.
Well, and you raise a good point with regard to the modification issue, because spousal support is modifiable, and cohabitation or remarriage is not an automatic termination in Oregon. So any unanticipated change in circumstance would permit either party to ask the court to modify it. So that's an excellent point.
Um, I've got a question for you, Heidi. If somebody is considering divorce, should we be mindful of joint liquid assets? And should they, or one of the party or the other, consider freezing accounts?
So I'm not a proponent of self-help. I believe that, and I think the court's desire is that financial status quo be maintained while a case is pending. Prior to a case being filed, there's no case, there's no orders in place, there's nothing. And so really either party is able to do what they want to do with their money. However, if you really are hoping to bring the other side to the table to negotiate an amicable settlement, and then you freeze accounts or you take half of the money out of the accounts, that's taking an aggressive action that is not going to motivate somebody to come to the table and negotiate a settlement with you. So I generally recommend, unless you've talked with a lawyer and there's some really good reason to do something like that, that you don't take that kind of an action. Now, once the divorce is filed and served on the other side, there is an automatic financial restraining order that goes into effect, which does in fact prevent the parties from doing certain things. Closing accounts, making expenditures that would be unusual, changing beneficiary designations, and that sort of thing. That's after the case is filed.